Ghislaine Maxwell's criminal defense dream team is now asking the court for a subpoena, not just any subpoena. They want access to information that relates to a victims fund that was set up for the victims of Jeffrey Epstein. So they submitted this motion. It's going to a woman named Jordana H. Feldman, who is the administrator of this victims fund. And we can read through it and see what Maxwell's defense team wants. Why do they want this subpoena? What information do they hope to get out of it? Let's take a look at the minute entry and see if we can piece this together. On November 21st, you can see that there was a motion authorizing a subpoena pursuant to the federal rules of criminal procedure. This was documented and filed by Ghislaine Maxwell along with different attachments and exhibits filed by Jeffrey Pagliuca. We talked about him. He's one of Ghislaine Maxwell's defense lawyers. And then shortly thereafter, we see even though these are out of order, we see a letter here from Jordana H. Feldman. What's happening here is there was a subpoena that was requested by Ghislaine Maxwell's defense team to go towards Jordana Feldman. She is the administrator of the Epstein Victim Fund. If we plot that on a chart, it is looking like this. It's Ghislaine Maxwell through her defense team, except this would be Jeffrey Pagliuca, asking Judge Allison Nathan for an order so that they can go back out down here and get this person, Jordana Feldman, to come into court and testify or to produce some sort of documents. And so what Jordana Feldman has already done is they've responded and they're saying, Judge, don't grant this. We don't want this to happen. And we're going to get into both of those documents here. Let's start off with the motion from Ghislaine Maxwell's defense team. Here's what it looks like. It's a motion for an order authorizing a subpoena. And you can see the primary attorneys on here are Jeffrey Pagliuca and Lauren Meninger. We talked about them in our Defense Dream Team video about Ghislaine Maxwell. Also signed off on by Bobby Sternheim and Christian Everdell. You can see it is being filed out of the Southern District of New York, where the case is being held. 9 pages. We'll go through it relatively quickly. Here, you can just see they're asking the court for a subpoena. Issue a subpoena. They want it to go to Jordana Feldman, who is the administrator of the Epstein Victims Compensation Program. What do they want? They want certain items that are identified in Attachment A. Background, October 11th, the government began producing 3,500 material to the defense. This is called standard disclosure material. These rolling productions confirm that 4 accusers referenced in the indictment applied for and received millions of dollars from the Epstein Victim Compensation Fund. 4 accusers got paid millions of dollars. Ms. Maxwell requests the court assistance in subpoenaing those documents submitted by the accusers and the witnesses for use at trial. All the documents that went into those Victims Compensation Fund requests, Maxwell's team wants those. The documents should be returned to the court for an in-camera review. Subject to the court's review, disclosed to the defense to be used for the impeachment of the witness at trial. Okay, what's happening here? So, Ghislaine Maxwell is now on trial. Her defense attorneys are saying, we want access to any of the application documents, any of the correspondence, emails, phone calls, letters, notes, interviews, anything that these alleged victims used in order to get compensation out of the Epstein Victims Compensation Fund. You have accuser A, for example. She says, I was abused by Epstein. I want compensation. She goes, she sits down. They say, well, tell me about your claim. And she tells them about the claim. And they say, it sounds like a pretty good claim. Here's $1 million. All of that transaction was documented. And so what Ghislaine's attorneys are saying is that if that same person, if that accuser is going to say, I was the victim of Epstein, and Ghislaine Maxwell was Epstein's number 2, and she was helping to facilitate this abuse, and she's on trial for this, and one of these accusers is accusing her of this criminal activity, Ghislaine is saying, I want to be able to see what that accuser said to the Epstein Victims Compensation Fund, because I might want to impeach them using that document, that information. In other words, if accuser A comes into court during Ghislaine Maxwell's trial and says, Ghislaine did this to me, but there are documents from her settlement with the compensation fund that say Ghislaine didn't do that to her, that's a contradiction. That's a difference of a statement, isn't it? And so you can use that prior statement that is inconsistent to impeach the inconsistent statement at trial. So Ghislaine's attorneys are saying, we want access to all of that information so that we can use it to impeach these accusers who are accusing Ghislaine Maxwell of these crimes. And the courts are saying, and they're asking the courts for permission to go get that information. They use the legal standard. They tell us Rule 17C permits subpoenas that compel the production of books, papers, documents, and other information. Most districts, courts, and the Second Circuit, including this court, use this analysis that the party requesting the information, pretty low, must only make a preponderance showing the materials requested are relevant, specifically identified, admissible, and not otherwise procurable by the exercise of due diligence. Okay, that's the standard. Why should Ghislaine Maxwell's defense team get those documents? Well, they're going to say they meet those standards. It's relevant. It's relevant to an accuser. Ghislaine Maxwell is being charged for crimes based on these types of accusations. We've identified exactly what it is. We don't need every single document. We just need the documents from that one person and that one settlement. It's saying they're going to argue it's admissible. It's not otherwise something that they can obtain by due diligence. They need a subpoena. They can't just Google search this information. They've got to go get a subpoena to go dig that out of the Epstein Victims Compensation Fund. So they're going to try to make that case. They also talk a little bit more about the factual and the procedural history. So allegations in the superseding indictment. Count 1 and 3 of the indictment allege that Ms. Maxwell conspired to violate two separate provisions of the Mann Act. Count 1 alleges that Ms. Maxwell conspired to entice, quote, one or more individuals to travel for certain activity. Count 3 alleges similar stuff. Counts 1 and 3 allege overt acts purportedly involving accusers 1, 2, 4, and witness number 3. Okay, so talking about the indictment is talking about the same groups of people. The same people that justify the indictment against Ms. Maxwell are the same people that are going and collecting some money from the compensation fund. Count 2 and count of the S2 carries on. Counts 2 and 4 concern accuser number 1. Counts 5 and 6 now talk about Maxwell violating the federal trafficking statute. A lot of this is sort of heavy legalese, so we can kind of skip through it, but I pause if you want to read it. Both counts are based on allegations of accuser 4 and talk about conduct that allegedly occurred between 2001 and 2004. Then we get a lot of redacted stuff. So they give us some procedural history here, and then we now get into some of the meat and potatoes. First sentence, of course, redacted. Paragraph B, the accusers and the Epstein Victim Compensation Fund. We start off blank, pick up. Ms. Maxwell was not mentioned in that lawsuit. Accuser 4 and witness 3 applied to the Epstein Victim Compensation Fund. All 4 women chose to accept compensation from the fund. In its disclosures, the government has provided statements from the accusers indicating blank, 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 blank. Don't know what the accusers indicated. Did they say something happened about Maxwell? Epstein did something that don't know what it says. The protocol for receiving compensation is attached. The protocol requires a written submission. So that's what they want. The claims are evaluated per the protocol, which is in that document, which I will post over on watchingthewatchers.locals.com. The claims are evaluated per protocol, which credits, quote, whether there exists any information or pertinent findings offered by the appropriate office of the district attorney, U.S. attorney's office, or other law enforcement attorney. So what it's saying here is if you're a claimant, if you're somebody who was abused by Jeffrey Epstein and you want to go and get compensation for that, one of the things that they'll look for under the Epstein Victims Abuse Protocol is whether or not there are pertinent findings from the relevant district attorney's office, U.S. attorney's office, or any other law enforcement agency. So somebody comes from Idaho, Boise, Idaho, and they say, Jeffrey Epstein abused me. And they say, okay, well, we're going to go check with the Idaho State Police, the Idaho Sheriff's Office, the U.S. Attorney's Office out of Idaho, and we're going to go see whether they have any information about this abuse. Because if you didn't tell them, well, maybe you're just a big liar, aren't you? Or maybe if you did, we should send some people over there to make sure that nothing comes of it. Accordingly, the protocol credits claimants who have filed charges against Epstein or any employee of Epstein. June 2019 indictment against Epstein did not include the allegations of 4 accusers that are contained in the indictment charging Maxwell. Under the terms of the protocol, the accusers here and their civil lawyers stood to benefit if the prosecution against Maxwell went forward. Protocol also so in other words, if the prosecution goes forward, then they have something on the record so that they can use that in order to go get compensation. The protocol also rewards accusers who have filed a lawsuit, legal action, or any claim against Epstein. Lawyers for Redacted were instrumental in creating and structuring the terms of the protocol. See, for example, Redacted. So, what they're saying here is that these accusers have a pretty strong incentive to bring charges against somebody else, because if they do, they can take proof of those charges and go back to the compensation fund and say, well, give me my money because this was serious. It was so serious that I filed charges against these other people. It's sort of like if something's stolen out of your car and you need to replace it, you go and you buy the replacement thing, you take the receipt and you show it to your insurance company and they reimburse you for that. Here, you go to the victim's compensation fund and you say, I was abused by Jeffrey Epstein. And they say, well, you don't have a receipt for that. And you say, well, hang on a second. So then you go over to the sheriff's department and you say, Jeffrey Epstein abused me. And they say, oh, wow, this is horrible. So they write a police report. Then they give that back over to you. Then you take that over to the victim's compensation fund and you say, here's my receipt. And they say, here's $1 million. Great. But that police report was now towards Ghislaine Maxwell. So that's what Ghislaine Maxwell's attorneys are arguing. They talk about this. They say that this is also appropriate for 3 reasons. One being specificity. So the protocol that was created by the Epstein Victims Compensation Fund establishes a process that all claimants must follow. So if you've been abused now, you have to do the following. You have to submit a claim form with documentation. These claims are then evaluated based on the criteria of the protocol. Any deficiencies in the claim are notified to the claimant. It's like applying to college, essentially. You know, you go to college and you apply to college and you say, hey, I'm a great student. I love your school. And they say you have to submit 2 letters of recommendation and you're missing those. And so then they send you an email. Your file's incomplete. You're missing your letters of recommendation. Same thing here with abuse. So if a claim is approved, the administrator sends the claimant an offer letter and a release. Miss Maxwell is requesting specific documents identified in the protocol, including the claim form with any supporting documentation, correspondent between the claimant or her attorney, and a copy of the check that was issued by the claimant as well as a release signed by the claimant. So they want everything that happened here. Admissibility. They're talking about why this information should be admissible. They're saying, Judge, give us the subpoena because, first of all, it's very specific. We told you exactly what we need right here. The check, copy of the protocol, the written claim, the response. That's it. We don't need an entire fishing expedition. We don't want all their files, just these detailed things. Also, Judge, they say if you grant us this subpoena, it's going to be admissible. There are no evidentiary impediments to admissibility. Documents are relevant. They're authentic. They have the appropriate evidentiary foundation. We can establish those under the rule of evidence. The claim form is a prior statement of the accusers. They said it. And they are admissible impeachment evidence at trial. Very relevant to impeach them. And they're saying we're going to do that. And finally, they also tell us that it is relevant. So Ghislaine Maxwell's lawyers say, in addition to being specific, in addition to being admissible, it's also very relevant. As previously stated, redacted. Oh, don't you hate that? Miss Maxwell was not mentioned in the lawsuit. Accusers 4 and witness 3, they applied to the compensation fund. All 4 women here chose to accept compensation from the victim fund. In its disclosures, the government provided statements from the accusers indicating redacted. Punks. The protocol for receiving compensation is attached as Exhibit 1, which is posted over on watchingthewatchers.locals.com. Protocol requires a written submission. Claims are evaluated, goes through a number of different processes. Protocol credits claimants who have had charges filed against Epstein's It carries on. The protocol also rewards accusers who have filed a lawsuit, a legal claim. Lawyers for blank were instrumental in creating and structuring the terms. The documents sought are obviously relevant. Statements of the accusers were made for the purpose of securing a settlement. Similarly, the amount of the compensation is also relevant, they say. This trial, according to Maxwell's attorneys, will turn on credibility of the individuals accusing Maxwell. The court should allow broad cross-examination during the trial on general issues of bias and motive for fabrication to protect Maxwell's rights under the Confrontation Clause. A criminal defendant, quote, states a violation of the Confrontation Clause by showing that she was prohibited from engaging in otherwise appropriate cross-examination designed to show a prototypical form of bias on the part of the witness, and thereby to expose the jury to the facts which jurors could draw reasonable inferences from. The exposure of witnesses, and we have some other statements there. Maxwell's lawyers say full and complete cross-examination of the accusers is impossible without understanding the complete terms of the agreement with the Epstein Fund, including the claims concerning Ms. Maxwell and others. They talk about impeachment evidence is especially likely to be material when it impugns the testimony of witnesses critical to the prosecution's case. So they say that these accusers have a lot of bias here. Not only was it a compensation bias, but there may be some other biases that we can't glean here because everything is redacted. But this is a problem. The accusers were compensated. We've seen this in other cases. In the Kyle Rittenhouse case, which we covered a lot here on this channel, remember Gage Groskowitz? He was impeached with that lawsuit that he filed for $10 million. The defense said he had 10 million reasons to concoct the story. What about these accusers here? Ms. Maxwell's lawyers are arguing that, yes, they do. They were all compensated. The compensation was predicated on the idea that something had to be moving forward legally against some of the defendants. In this case, Epstein was dead. Maxwell's still alive. You've got 4 accusers who say, oh, there's a huge compensation fund. I want millions of dollars. I'm going to come up with allegations against Ghislaine Maxwell. So Maxwell's attorneys are now, rightfully so, identifying this bias, asking the court for a subpoena. They're probably going to get it. You can see this was signed off on by Jeffrey Pagliuca, and the people upon whom the subpoena will be served have already recognized that they're going to have to file a motion to quash. You can see that shortly after that document was sent over, Smith Villazor sent an email back over to the honorable judge. They said, Honorable Judge Nathan, we represent Jordana Feldman. She is the independent administrator of Epstein's Victims Fund. This is the litigation alternative program that is established to confidentially resolve claims of abuse against Epstein and his estate. This afternoon, we were informed by counsel for the government that the defendant has sought and that the court intends to authorize a subpoena directed to Ms. Feldman under the federal rules. We write to inform the court that we are going to accept service on behalf of Ms. Feldman, and we would like a briefing schedule for Ms. Feldman's anticipated motion to quash the subpoena. They're going to fight this thing. We understand that the government intends to file a motion to quash the subpoena with a deadline Wednesday. Given that we just learned of this, we'd like to be mindful of the impending start date of trial. We respectfully request until November 23rd to file a motion to quash. Respectfully submitted, Patrick J. Smith from Smith Villazor. So, sounds like the court is inclined to grant this subpoena. Sounds like it is pretty legally relevant. A lot of very good information is going to be kept in the houses of the Victims Compensation Fund that Jeffrey Epstein ran, or that Joanna Feldman is actually running. And so we're going to continue to follow this case. We're going to see what the motion to quash the subpoena looks like. We're going to cover all of the other minute entries and all the little nuggets and details that we can glean out of this very important Ghislaine Maxwell trial. I hope that you stick around and join us on the next one. Would appreciate it if you subscribed, liked the video, left a comment down below, and of course, shared it with a friend or somebody that you love in your family. Thanks for being here. I will see you on the next one.